Hi, this is Suzanne Bichard, instructor for American Institute for Paralegal Studies. We start out in a estate and trust law class talking about wills, and this lecture is going to focus on the question of what happens when somebody dies intestate or without a will. We'll also discuss some of the advantages of having a will and review a few of the tasks that paralegals perform in an estate law practice. First of all, what is a will? Well, a will is a legal document in which a person, called the testator, formally declares how his or her property should be disposed of after death. Some important characteristics of a will are that the will is revocable during the lifetime of the testator, and it's not operative, that is, it doesn't take effect until after the testator dies. So what happens when somebody dies without a will? Well, when a person dies without having written a will, his property passes according to the state laws of intestate succession. All U.S. states have statutory schemes that dictate how a decedent's property will pass when the person dies without a will. Intestate succession laws vary by state, but in general, intestate succession laws do the following. They determine the identity of heirs, set forth the rights of family members, establish guardianship for any minor children, contain procedures and rules for the administration of the estate, the appointment of the personal representative or administrator, and the disposition of the estate property to the surviving spouse and any blood relatives of the decedent. As you can easily see, when somebody dies without a will, the laws of intestate succession take over and determine what happens to the person's property. Unfortunately, this may not necessarily conform to the decedent's wishes, and that's one of the big advantages for having a will in the first place, to make sure the client's wishes for the distribution of his property are carried out. So what are some of the other advantages of having a will? Well, the advantages of having a will are that you can select the people or institutions that will inherit from your estate. You can name a guardian for your minor children. Choose who will be the personal representative or administrator of the estate. Determine the source from which taxes and other debts will be paid. Appropriately provide for any survivors. And you can use the will as an opportunity to pre-plan the funeral and burial. You can also leave property to others in trust. And these are just a few of the advantages of having a will. Now, some of the tasks that paralegals often perform in an estates and trusts practice include preparing drafts of wills and reviewing them with the supervising attorney prior to execution by the testator. Upon the testator's death, the paralegal is often involved in helping gather documentation and keeping track of expenses of the estate. Now, if you're not currently a student at AIPS, and if you'd like more information about legal studies leading to careers in the law, please visit our website at aips.com.